Hello, I'm Arizona lawyer Julie LaBenz. Thank you so much for watching this video. Today, I want to talk about why you must make a settlement offer. This is a big mistake that many self-represented parties make, is that they just think, oh, I'll let the judge decide. I'll just go to trial. But you've got to know that going to trial takes the longest, and you're putting everything into the hands of the judge, which you may or may not be happy about. That also means that you need to prepare for and conduct a trial, which is a lot of time and effort and learning on your part. And honestly, judges really don't want to make a lot of decisions for you in your case. When it comes to family law, judges really want the parties to resolve their own problems. In other words, the judges aren't looking to decide what is best for your family. They would rather have you and your ex decide that, particularly when children are involved. Another thing to be cognizant of is that if you let the judge decide everything for you, you're also opening yourself up to a potential appeal process. And that just means more time, more expense, more uncertainty, more divisiveness in your overall family situation. And if you have kids together, learning how to negotiate and reach agreements with your ex can be a really great skill to start building now, because over time, as your kids get older, there will continually be decisions to make regarding making changes to your parenting plan and working together in the best interest of your children. So if you can start building those skills now, that is really helpful. So when do you make a settlement offer? What does it look like? How do you go about doing this? Well, you can make a settlement offer at any time. I mean, most importantly, you need to have sufficient information to do so. You'll need to have, records if, for example, there's financial issues that you're going to make a settlement offer about. You'll need to know, for example, what each side's work schedules are going to be. If you're looking to talk about parenting time, because often that can be a factor in determining what is the best parenting plan to move forward with. So make sure you have all the information you need. And sometimes you realize this once you sit down and start drafting a potential offer. And what you'll want to do is have that draft going and make some notes about what you need to put yourself in a position to make an offer, and then take the steps to gather that information, be it through legwork you can do on your own to gather it, if it's something that's within your possession or control, or making a request that the other side produce particular information if you're needing that in order to make an offer. For example, if you're wanting to make an offer regarding child support, but you don't know all the details regarding your ex's current gross income, then that can be a great time to make a request for their affidavit of financial information, their pay stubs, their bank account records, employment records, whatever you will need in order to determine what their actual current gross income is for purposes of calculating child support. So make sure you have all of the information you need to make an offer. Of course, you can make a partial offer if you want to start engaging in negotiations but don't have all the information. You could always set certain issues aside for further negotiations once you have everything you need. However, like I said, sitting down and starting to make an offer and really realizing what else you need to make that offer can really help you keep your case on track and organized. So this is a great exercise to go through. Now, once you have all of the information that you need, you want to make an organized offer. You're going to want to go step by step by step. In other words, item by item, issue by issue. Number one, division of property. Part A, real estate. Part B, bank accounts. You want to go step by step and make a clear offer about each item or issue that is relevant in your case. So as you're going through, you can put this in an email, you can put this in a letter, but keep it very organized, have headers for the different sections, and make clear offers for each part. As you're doing that, and of course, you want this to be comprehensive, you want this to be clear. This can also be a really great time to, in just a second, let me cough real quick. This can be a really great time to consult with a lawyer. If you're able to do that, you can draft your offer, take it to a lawyer, just pay for a certain amount of their time, maybe 30 minutes up to an hour, I would say at the most, and to have them help you, by reviewing your offer and make sure it's clear, and to suggest any additional terms. That can be a really great use of a lawyer's time without having to break the bank by hiring a lawyer full-time. So you want your offer to be very clear and concise. You want it to cover as many issues as possible. If you are not in a position to cover each issue, then make clear that this is a partial offer and make a list of what issues remain outstanding to be negotiated at a time in the future. So just stay very organized and stay very clear with what your positions are regarding each issue. Once you have that together, at the end of your letter or email, you want to include a deadline. This is really important. This is important for a number of reasons. Number one, maybe you end up changing your mind, and then, if they don't respond or they reject the offer on or before the deadline, this gives you the opportunity to make changes rather than it just being this offer that's open indefinitely. Also, and most importantly, by having a deadline, you're keeping the discussion on a timeline. You're not just giving them months to consider it and then get back to you. This is keeping things moving forward on a reasonable pace. I would say a week to 10 days is a reasonable amount of time to put a deadline for your offer. I often include language saying, here's the deadline, specific date and time. However, if you need additional time, please let me know and we can discuss an extension. In other words, I'm not saying this is it, you have to respond by this date. Instead, I'm allowing the date to potentially be extended, of course, not by a lot, but upon a mutually agreed upon additional amount of time. But I also want them to be clear that, I want to get a response and I want to keep this matter moving forward. So make sure, it's just as a recap, make sure you have all the information you need. Have a very clear and concise settlement offer that covers the exact terms and has very clear language. You want it to be more comprehensive than less. Have a deadline for your offer, and then you'll want to send that out. It's really important to engage in settlement. The judges want you to do it. You can be seen as unreasonable if you don't. Now, if you receive a settlement offer from the other side, either if your ex is representing themselves or if it's from a lawyer that's representing your ex, you must respond. Now, of course, you can let the deadline pass. If you let it pass, that's deemed a rejection. But it's important to respond and not just say, no, I disagree. It's really important to go point by point and indicate what you disagree to and why, because that is what facilitates negotiations. First of all, you may be able to reach some partial agreements if you go through and there's certain things that you are in agreement with. And then it also allows a dialogue to be opened on the points where you're in disagreement, especially if you're providing the other side with the reasons why you disagree, because then you can, the two sides can start to decide, okay, can we meet in the middle? Is there any sort of negotiation that can unfold that can actually get us to an agreement. And if there is no way to meet in the middle or resolve that issue, it's also giving you gold as far as what you want to do at trial on those issues, because then you have very clear information about what their position is, what your position is, and you can craft your arguments for trial. You can gather the evidence that's in your favor on these highly disputed points to seek to persuade the judge to rule in your favor. So you really want to engage in these settlement negotiations. Also, if you're set for a mediation or a settlement conference, I highly encourage you to make a settlement offer before either of those, because it starts getting the negotiations going. You only have so much time at these mediations and these settlement conferences. And if you've already started the dialogue of the negotiations before you even walk in the door of the mediation or settlement conference, you are really helping to facilitate and increasing the likelihood that a full agreement can be reached. All right. If you have any questions, please put those down in the comments. I am excited about creating future videos that address any questions that you put in the comments. Also, if you found this video helpful, I would love it if you would like it, subscribe, share the video. And overall, just thank you so much for watching this. I wish you so much luck in your case. Certainly representing yourself in family court is no easy feat, but hopefully this information is something that is helping you to move forward. So thank you so much for watching, and I wish you all the best with your case.